SJC-11812, Commonwealth versus Diaz.
Mr. Crouch, good morning.
Good morning. Andrew Crouch on behalf of Faustino Diaz, who appeals from a single conviction of first-degree murder out of the Hampden County Superior Court. This case, as your honors are aware, involved a 20-year-old cold case investigation that eventually culminated in the arrest and charging of Mr. Diaz. The issue that we raise in the brief specifically relates to the propriety of the closing argument, the summation statements made by the Commonwealth, specifically 5 particular statements made in this context. At the outset, we certainly acknowledge that the Commonwealth's main area of evidence here, their main focus was on the DNA evidence that linked Mr. Diaz to this particular offense, specifically relating to biological material that was found at the scene of the offense. But we would put in this particular context, the question is whether or not these statements made in the Commonwealth summation rose to the level of substantial likelihood of a miscarriage of justice. And specifically, we would say even in light of the DNA evidence that we have here, that doesn't obviate the need for this particular type of review, and that there certainly are circumstances where the Commonwealth may exceed the propriety of what they're allowed to say, the bounds of what they're allowed to say, even in light of otherwise strong evidence. The particular evidence that we are looking at here, as I noted, relate to 5 particular statements that the Commonwealth made. We start with the issue of the prosecutor saying in closing that the defendant cried uncontrollably when confronted with or when provided the information with regards to the victim's death. Here, that exchange that occurs with Detective Muse is one in which he is asked how the defendant responds to the information when he is told that the victim has died, and that is not in 2012. That is back in 1991, just days after the murder happens. And the record demonstrates both in the defendant's statement and in other evidence there that the defendant knew the victim, describes her as a very nice lady in his own statement. So it's not that he has no familiarity with her. But when the Detective Muse is testifying, he says that that his response is an extremely emotional response. That he starts to cry when he for several minutes when he's told this, and then he says. This is a response that I haven't really seen in similarly situated witnesses in similarly situated cases. That is a timely objection at that point. Then the judge's response is to say that observation is the objection is sustained as to that observation. There really isn't much elaboration, but I would say if we break that down. The Commonwealth then relies on this on 2 separate occasions to suggest there is a consciousness of guilt on behalf of the defendant, and going so far.
But two things. After the objection was sustained, weren't there further questions that were asked that confirmed that he did indeed cry and that none of the other individuals the officer questioned had cried?
Well, I think my memory was that he then elaborates as to the length of the crying. He says it went on for several minutes. But that, my memory is not that there was additional criticism or additional commentary by Detective Muse, such as that had already been sustained in the objection to that observation by Judge Sweeney here. But specifically what had happened was the Commonwealth had relied on this in suggesting that there was indeed some great consciousness of guilt on his behalf because he, taking that next leap, that he was then, he at that point realized that he was going to, he might be arrested or that he was somehow going to be charged with this. But here, while it is a little bit unclear as to what Justice Sweeney's, what exactly was struck or not struck at that point. You know, I would suggest that when we look at it, when he's, you know, Detective Muse is certainly able to testify as to what his observations are. When he starts to qualify and characterize those observations, when he starts to state what, you know, his opinion on those, I think that goes beyond the bounds of what he's supposed to say. And certainly when he starts talking about, you know, his response compared to other cases is beyond the pale. So I would suggest that those two statements in what basically is one sentence that is followed by an objection. It's not multiple questions.
Yeah, I think there were multiple questions. We'll hear from, I recall there being, from the record, there being questions that were asked after the objection, which seemed to say that he cried and nobody else who I spoke to cried. I mean, isn't it, the death of a 91-year-old woman is a tragedy, but not an unexpected one. I mean, isn't it relevant that the janitor in the building, who does not have a close relationship with her, is suddenly uncontrollably crying when he learns of her death?
Well, I would say on the first instance, and this will lead into the second issue. In the first instance, you know, it is the prosecutor's own characterization that it is uncontrollably. I would suggest that potentially Judge Sweeney had restricted that, had struck that particular language.
Okay.
But putting that on, it's not that he had just been informed that she had died. She had been informed she'd been murdered. And so that is a far different situation. And he says in his statement, he acknowledges that he cried. He acknowledges because he said that she was a nice lady, he's somebody that she was familiar with, and I would suggest that that is not a particularly unusual reaction to somebody being told that a 91-year-old person that he knew had been murdered. And the Commonwealth does, in its brief, suggest that you know, that he didn't know the means or how that offense had taken place. And I would suggest, you know, just knowing enough on the murder point, you know, that the person had been murdered is disturbing information that might elicit an emotional response. But that is specifically the second point with regards to not knowing how she died. As I said, you know, Detective Muse himself testifies that no, I told him that he was murdered. They hadn't gone into all the graphic details quite yet. Moving into the third issue, the prosecutor, sort of out of nowhere, in trying to come up with a motive for what happened here, suggests just sort of on the fly that you know, did the person have, you know, did he have a drug problem? I don't know. The medicine cabinet was left open in her bathroom. The evidence in the record, there was no evidence to suggest in the record that the defendant had any sort of that there was any motivation for drugs. There was, first of all, no suggestion that he had any history with narcotics or any kind of controlled substances, let alone a problem. There was no suggestion that there were any sort of narcotics or drugs on the location. And the testimony from Detective Muse, I believe, or it may have been Officer Mulvey, was that the medicine cabinet was just slightly open. It's not that things were all strewn all over the place with respect to there. So I would suggest that when and as I said, this is all in the light of obviously DNA evidence that is in this case, but here, where the prosecutor is injecting something that's not based in the record, it goes beyond the scope of any information that was there, but also injects this whole other potential motivation that this is somehow a nefarious drug, attempt at drugs, is just something that just injects either a suggestion of personal knowledge that go beyond the scope of what was in the record, or suggests that a personal opinion or something. But what we do know is it certainly exceeds the bounds of what was actually in the record.
Well, I mean, I take your point, but it was in the context of saying, ultimately, she says, we do not know why he killed her. It's a senseless murder, and I don't need to prove motive. So, I mean, it's not, I take your point that it probably would have been best left alone, but it wasn't carried. I mean, how was this carried to the point that it would be a substantial miscarriage or substantial likelihood in view of the fact that there was no objection to it?
And I certainly acknowledge the lack of objection here in the standard that it puts us in. And I think we're sort of looking that it's not any one particular statement here, but it's more the cumulative nature of everything that was said here. Certainly better left unsaid, but it does, as I said, even though it is followed by I don't know, certainly better left unsaid, but also just adds this nefarious element to it that is just sort of injected out of, from no basis in the record. And then moving on to, to one of the last points here is just that, the contention from the prosecution that is done right towards the end of the argument to suggest that, that the victim during the entirety of this situation was sort of alive and suffering, to use the words of the prosecutor, when that also is not, I would suggest, not a fair inference based upon the medical evidence that we had seen in this case. The original medical examiner was unable to testify, so Dr. Niels testifies. And Dr. Niels, says that, is pretty careful in what he says about, how this particular victim died. Talks about, certainly she suffered multiple blunt force trauma, but is not making a statement as to specifically when that happened. Acknowledges on cross-examination that a single blow for somebody of this age with these types of injuries could have been sufficient to have caused her death. Doesn't get into any greater detail. The prosecution then will talk about, starts asking, well, how did she get these bruises? How did these things happen on her hands or her fingers? There isn't any medical testimony as to how any of that occurs. There's no basis in the record for any of that. I would suggest that that extends beyond the realm of what should have been said in this situation. And when we look cumulatively at all of these, individual statements, I think we do see that this rises to the level. As I said, I certainly acknowledge that there is, DNA evidence here, and that plays a substantial factor in the jury's verdict. But that doesn't obviate our need to review the case, and it also does not extend beyond any bounds the possibility for the Commonwealth to raise challenges or to raise inferences that are not drawn from the particular record. And we would ask this court to reverse Mr. Diaz's conviction and remand this for a new trial.
All right, thank you. Ms. McMahon, good morning.
May it please the court, Catherine McMahon, Assistant District Attorney for the Hampden District for the Commonwealth. This is not a case where there was DNA at the crime scene. There was the defendant's DNA in and on the victim's body. And the evidence, although circumstantial, proved overwhelmingly that she was strangled and beaten while she was being raped both vaginally and anally, and that the defendant was the assailant.
Am I correct that the DNA came only from the area around the anus and not from the vagina?
They tested the perianal and the anal rectal, so there was sperm on the vaginal swab, the perianal swab, and the anal rectal swab. It was the anal rectal and the perianal swabs that were tested for DNA, and the defendant's DNA was, well, to the quadrillions matching the defendant's was found on both those swabs.
I guess I was confused. If there was sperm in the vaginal area, why was that not tested?
I don't know. That was collected in 1991 at the victim's autopsy. I don't know why or what happened to that swab. The testimony had to do with observations of sperm on all three types of swabs, and then in two DNA analysts testing the anorectal and the perianal, and it being the defendant's, and also that the non-sperm fraction matched the victim's. There was a vaginal tear in the victim's wall, which the medical examiner said was suggestive of blunt trauma to the vagina. She was also bleeding from the rectum. So it's not just that there was intercourse. The evidence, including the strangulation and the beating, which was enough to cause like concussive damage to her brain, petechial hemorrhages, broken ribs. I think almost every bone in her face was broken. The rest of the apartment was neat and tidy. The blood and the victim were all in her bedroom. Her underwear was on the floor, her clothing was pushed up, and her buttocks were exposed. So it's, although circumstantial, overwhelming evidence that she was raped and killed in the bed at about the same time, and that it was the defendant. None of the claims that the defendant now raises were objected to at trial. This was a substantial likelihood of a miscarriage of justice standard. I submit that the prosecutor's arguments, for the most part, stuck with the evidence and its reasonable inferences. In terms of what Detective Muse said about his observations of the defendant when he interviewed him a few days after the murder, he said his demeanor was over the top, that he cried, and he said that he had never seen a similar witness in any case act like that. The Commonwealth submits that that last line, that he'd never seen another witness act like that, was the objection that was sustained by the trial judge. The prosecutor, as you note, then questioned Detective Muse again. Detective Muse said that the defendant had cried for at least 5 minutes, and none of the other witnesses he'd interviewed in this case had acted that way. So it was in the evidence, it wasn't struck, it was demeanor evidence that suggested the defendant's consciousness of guilt and knowledge of how brutally the victim had been killed, not just that she had been killed, and a proper demeanor evidence that the jury could consider on those questions and that the prosecutor could argue on those questions. In terms of the bloody towel in the bathroom, the towel is Exhibit 13. You can examine the towel. There's no observable blood on the towel. The victim's daughter-in-law had been the one who discovered her body. She saw the towel in the toilet. She said that the water was clear. A police officer testified to collecting the towel, drying the towel, and then submitting it in evidence, but there's absolutely no evidence that the towel was bloody. So the prosecutor's suggestion that there was so much blood that he had to throw the towel into the toilet is not supported by the evidence, but the inference, which even defense counsel acknowledged, was that the bloody assailant had washed up in the bathroom, was supported by the evidence, including evidence of blood trace on the kitchen and the bathroom sink, the victim's purse being dumped in the sink and being wet, and the fact that the towel was used.
Well, I mean, but the only relevance, based on the closing that I could tell, was to explain, to indicate why he suddenly stopped wearing work clothes after the date of the killing.
Yes.
With the implication being that those work clothes were bloody, had blood on them, and therefore he'd stopped wearing them. And that's the only relevance to...
And that's an absolute fair inference. The victim's room, there's blood up the wall, there's blood on the curtain, there's blood in the bed, and on some of the furniture. She was beaten, and she was strangled, and she was raped, so the assailant had to be in close proximity to her. She bled profusely. I put photographs of her injuries showing the blood in the Commonwealth's appendix. It's reasonable to infer that the assailant would have gotten blood on him, and a significant amount of blood on him, based on the need to be physically close to her and the injuries. Then there's the blood stains on the sink in the kitchen, and the fact that, as defense counsel acknowledged, there'd been a washing up in the bathroom. So whether the towel had blood on it or not wasn't the probative point. The point was the assailant was bloody, the defendant never wore those clothes again, and shortly thereafter stopped coming to work at all, so that the defendant was bloody. And it's a reasonable inference, and the defendant's DNA is in and on the victim, so even if it wasn't, there's still overwhelming evidence that it's the defendant who was the assailant. As to the medicine cabinet being open, that wasn't the only evidence in the bathroom. The victim's purse was wet and it was spilled out into the sink. There was testimony that within like a month or two before the victim's death, the defendant had spoken to a coworker who cautioned him about approaching the residents, and he acknowledged that he had been asking some of the residents for money and he wouldn't do it anymore. So the fact that the medicine cabinet was open and that the purse was open and dumped out is suggestive that the defendant was looking for valuables, whether he was a drug user or it was something that he could sell or trade. That's a reasonable inference that when somebody's come in and they've opened drawers and cabinets, that they're looking for something. And it's still, as the prosecutor argued, it doesn't explain. There's nothing that explains this brutal killing, whether he was looking for valuables or not. And as she said, the Commonwealth doesn't have to prove motive. That's a collateral issue. It's not something that we burden. Her comments about that were not burden shifting. She wasn't looking to a response from the defendant to explain anything. She was simply saying it was a burden the Commonwealth didn't have. It's inexplicable, but there is still overwhelming evidence of the defendant's guilt here. So in light of the overwhelming evidence and the trial judge's instruction that the jury were the sole fact finders, that closing arguments are not evidence, that the jury's finding of the evidence controls, there's no error, there's no substantial likelihood of a miscarriage of justice. As to whether the victim was shielding her head or her face with her hands, again, that's a reasonable inference that the Commonwealth doesn't believe you require medical evidence. The medical examiner and the police detective who went to the autopsy both said that the victim had bruises on her outer hands. She had blood on the palms of her hands. She had fractures to several bones on her face. She had damage to her head. It's reasonable to infer that a person would raise their hands to shield themselves from blows. She did not die from the first blow. There was no testimony that the head blow that the ME conceded could immediately kill a 90-year-old woman was the first blow. And in fact, the evidence showed that she didn't die of a first blow because she aspirated blood. That meant she was breathing it, as the ME explained, which meant that she was bleeding before she stopped breathing because she breathed in the blood. And if consciousness and degree of suffering is not a fair inference, which I submit it is, there are still several other canine factors present from the evidence: the number of blows, the force of the blows, the different types of damage, strangulation versus beating to the head and the body, the broken ribs. There's also evidence of deliberate premeditation. The sustained beating and choking and raping shows a sustained intent to kill. It also was committed during the felony of aggravated rape with substantial bodily injury. The jury was instructed that the rape couldn't be felony murder if the rape was what caused the victim's death. The ME testified that what caused the victim's death was blunt trauma to the head and the chest. So there are other canine factors. There are two other theories of first-degree murder that the jury found the defendant guilty of, that there is no basis to grant a new trial. In the defendant's brief, he had asked for the case to be reduced to second-degree murder or manslaughter based on this overwhelming evidence of first-degree murder on all three theories. The defendant's conviction should be affirmed.
Okay, thank you.
Thank you.